Okay, great. Chris, thanks again for the Yacht Rock. Enjoying that very much today. Okay, so we're going to have our panel session here, and this will go about 30 minutes, and then we'll be all done. And I know folks from our team will be around, and maybe some of the panelists will as well. So if you have questions after this, just let us know. So I'm going to start by asking the panelists just to briefly introduce themselves, and I mean this sincerely. Each of them has a lot of great experience, and I just thank them again for taking time out of their busy schedules to be here today.
I guess I'm first. Thank you, Mark. My name is Matt Doscotch. I am Vice President of North American Legal and Intellectual Property for LivaNovo. We have products that are both in the cardiopulmonary space and the neuromodulation space. I think I've been practicing over 20 years, some 22 years, I guess, and 15 years total in medical device. I was previously with Zimmer Biomet and Orthopedics.
Hi, everyone. I'm Sandra Cito. I am the former Chief Compliance Officer at Cardiovascular Systems, Inc., and I say former because CSI was just recently bought by Abbott. So I'm in the process of transitioning out of my role there. I also just want to say that my comments today have nothing to do with the CSI acquisition by Abbott. There'll be general comments. I won't tell you how many years I've been in practice. It's longer than Matt. But I've been with CSI for almost 7 years, 10 years at Medtronic before that, partner at Dorsey before that. So I like to say I'm a little long in the tooth and I've seen just about everything. So.
Hi, everybody. I'm Gordon Weber. I'm General Counsel at Surmodics. Surmodics is a publicly held company, about $100 million in sales. Historically, we've been focused on coatings technologies that improve the performance of other companies' medical device products. So things like hydrophilic coating, hemocompatibility coating, drug-eluting technologies, those kinds of things. But recently, we've developed our own portfolio of medical device products, primarily in the thrombectomy area, and we're working on commercializing those. Prior to joining Surmodics, I was general counsel for 4 years at Vascular Solutions. That included the period during which the company and its chief executive officer were indicted for felony off-label promotion charges. We successfully defended those charges in federal court in San Antonio, Texas, and then about a year after that, the company was acquired by Teleflex. Prior to all of that, I was with Faegre Drinker, Faegre and Benson at the time. I was a partner in the corporate group during doing M&A transactions, securities offerings, and advising companies on public company reporting and governance activities. So,
Thank you, everyone. So I have a list of questions here in case you're wondering what we're all looking at. We prepared some questions, and if we do have time, we'll entertain some questions from the audience. Obviously, not specific to any one of the panelists, backgrounds or business. But I'll just start with the first question, and it's a two-part question. I'm going to ask Sandra if she can take the first shot at this one. So if you, and all the questions really relate, obviously, to all the material we covered today. So if you are looking at another company to purchase, how do you handle due diligence from a compliance, so specifically compliance perspective, and what do you focus on?
Well, I think there's a couple of things. First off, as much as we like to think that legal and compliance are the most important thing in the world, you have to realize that it's probably the tail wagging the dog in terms of due diligence. So you're going to have a limited time to do due diligence. You're not going to be able to do everything you want to do. You're not going to be able to ask all the questions you want to ask because, the marketing folks and the sales folks are going to take up all the oxygen in the room. So other thing to remember is that if you're looking to buy somebody, they're going to be subsumed within your compliance program as it is at some point in time. So really then what you need to focus on from a due diligence perspective is what are the specific risk areas of that particular company. Paul mentioned it when he was talking about the privacy aspects. Very much so, it's a sort of the same framework. Now, that doesn't mean you shouldn't ask general questions because you want to understand whether or not the target took compliance seriously. Did they have a compliance officer? Did they have a compliance committee? You kind of go through the 7 or 8 questions as Amanda talked about, or 7, 8 areas that Amanda talked about to really understand whether or not there's been a focus or even a recognition that compliance is important to the company. So you have to do those. But then really what you need to focus on and spend most of your time on is what are those particular risks of that particular company? Do they have a large sales force? If they do, then you're going to have to spend more time on what are the salespeople doing? Do they have a reimbursement hotline? You know, then you're going to have to look at that. Do they do direct to consumer? You're going to have different issues if they do direct to consumer. So it's really going to come down to really understanding the company, the target company's business. It's perfectly fine to ask questions about what do they consider to be their biggest risk areas, you know, from a compliance standpoint. But you really need to look at where do they focus their energies from a business perspective and really look at those areas very, very closely. That's just a general overview of how I would approach it.
Thank you. Anything to add?
It's a pretty
Gordon?
comprehensive answer. Yeah, I think you just really need to target your diligence efforts to the company and where it is and its development path, whether it's commercialized products or not, and you know, how the products are being used as far as what kind of exposure there might be.
Yeah, I would say spending enough time in the non-compliance legal folders as well, like to get that understanding up front. Like I'll spend more time up front there, which will allow me to spend less time, quite frankly, in the legal and the compliance folders.
I think the other thing you also got to remember is that the Department of Justice understands that if you're an acquirer, you're not going to necessarily know every last detail about the company that you acquire. What they're looking for is if you do acquire a problem, that you take care of it right away and remediate it completely. Now, it doesn't mean you might not end up with some kind of fine or something like that. But the idea is through due diligence, you really want to find those big rocks. You want to find those big issues so that you can adjust your merger agreement to address them. But if you find something later on, then what you really need to do, well, and also if you find something during due diligence, you really need to make sure that you've got an integration plan that includes how you're going to remediate the issue. But that's the most important thing. It's, in my experience, there's very few compliance issues that become deal killers. Now, it might be that they just got a CID and, you know, there's the start of a DOJ investigation. That clearly would probably be a deal killer. But besides that, there's very few things that you're going to find. And what you need to be able to do is be prepared to deal with them and take care of them after the fact. And frankly, do self-disclosure with the DOJ if you need to.
Great, thank you. So second part to that question, on the flip side, what do you do or what do you focus on if you are the target of the acquisition?
I liked Amanda's comment about not telling them what they ask you directly to tell them, but not giving them everything, because you can really get bogged down by providing them with too much information, too much detail. Frankly, the buyer will be overwhelmed because they don't understand the business generally. So keep it short, keep it brief, give them what they're asking for. And frankly, if you're the target, if there is something and that you know about or something that's happened in the past, be very frank with them and say, this is what the problem was. This is how we remediated it. This is now our status. And that goes a long way as well, because again, when you're buying a company, you just don't want surprises. You don't want to find out after the fact that there's this big issue that you knew nothing about. So be forthright.
I think the other thing I was thinking of is be cautious on the attorney-client privilege piece, because as the acquirer too, I don't want you to tell me that
Yeah.
because you're going to kill
Yeah.
the privilege,
Yeah.
which then isn't going to transfer in the transaction later,
Yeah.
which is a huge problem. So,
Yeah, I agree with the points about, you know, narrowly answering the specific questions that are asked. But to the extent that you do have your documentation in good shape, and you should know ahead of time whether you're going to face a transaction fairly soon. You know, it's a good time to beef up that documentation and maybe overwhelm the buyer with the quality of your compliance system so that they don't have as many specific, they don't want to drill in as much with specific questions, and they don't feel like they need to have the narrative description of what you're doing because you've got all this documentation that you can throw at them and they can send their associates off to work on it and check a bunch of boxes.
I just want to add one thing. In my experience, in my many years of practice, it's always been beneficial to really set the stage when you start having due diligence discussions. So if you're going to be part of a due diligence call where they're talking about compliance, say, I want to take the first 5 minutes and tell you about our compliance program, tell you about our risk profile, give you an overview of areas that you won't even need to think about because it's really not a risk for us. And that really helps a lot in narrowing down then the subsequent questions, the data requests, things like that. Because then they're like, oh, you don't have big operations in Europe. We don't have to worry about Europe, right? Or whatever the issue is. You don't have a reimbursement hotline. We don't have to worry about that. So it really helps a lot to set that stage and really give them as much framework to know what the business is. It also really then proves to them that you know what you're doing, right? That you have your thumb on the pulse of the organization so that they're not thinking, yeah, I'm not sure about this compliance officer. Or I'm not sure about this legal department. They don't really seem to know what's going on in the company. So that's another point I would recommend.
Great responses. Yeah, I've have talked to clients at times where they're about to go into diligence. Maybe they're a smaller company, so they haven't gone through that process. And I explain how it's a courtship, and you want them to have confidence in you. So I think that's a really great point, Sandra. Another thing, we have one of our teammates at Gardner Law is Tim Phillips, who's at the FDA for 32 years, and he talks about this acronym TLAST, which he learned from some attorney when he was at the FDA and preparing for litigation. And I think it applies to diligence. TLAST is an acronym, TLAST, and it stands for tell the truth, listen to the question, answer the question, stop talking, tell the truth. So I would, that we share that with our clients for like FDA investigations or OIG or whatever it may be. And I think it would apply here as well. So for what it's worth, I'll leave you with that. I'm going to move to the next question. And Gordon, I'm picking on you here. As you all know, approved products are often used off-label. So that was something I chatted about earlier. Off-label is this sometimes a bad word people think, but I often share with clients, it's actually lawful for the physicians to use approved products off-label if they want to. We just can't promote them for those uses. And we can even respond to questions if we follow certain safe harbors. So knowing that a lot of products that are approved are used off-label, and what that means is a fashion that's not consistent with the approved FDA labeling. So how do you figure out if a product is being purchased in an acquisition is subject to off-label use? So
I think it's a great starting point that it's not illegal to use a product off-label. The FDA doesn't regulate the practice of medicine. They regulate what we can do in promoting our products to doctors. So I think I would start with our own marketing people and see what they know about how the product's being marketed and used, most importantly used, and what kind of market need they're looking to fulfill by adding the product to the portfolio. And then with that understanding, I would go to my internal regulatory people as well to understand the labeling for the product, the approved indication for use, and make sure that they have a good understanding of how the product's being used in the field and whether that would require a specific indication for use. Nate talked about specific versus general indications for use. That is an important point, that if there's a specific disease state that's being addressed or a specific part of the anatomy, it may require a specific indication, and that should give you some sense for whether the use is within the approved indication or not. And then only with that as background would I go to the target company sales folks to talk with them about their understanding of how the product's being used. And kind of maybe as a last step, I would want to make sure that legal and regulatory are focused on the regulatory history, the clearance, the approval of the product as far as what kind of indications were initially requested versus what they ended up with. A lot of times you might ask for what you want as the indication, but the FDA can come back and tell you that it's going to be more burdensome to get that indication than you had hoped. So especially smaller companies, they'll take up the lower resistance path to an approval that might not have the indication that they want, and then that creates the opportunity for a lot of off-label use or use that the FDA thinks should have a specific indication.
Great, thank you.
Can I just add a couple of other things that potentially you would want to look at? One is having your marketing folks do a literature review to find out what docs are publishing about the product, because a lot of times that'll include a lot of off-label use before there's actual an indication. And then the other thing is potentially looking at your grants and what have you done from either an investigative research study perspective, giving grant money to have a physician do a study, or other grants that you've done, because that's also another way. It might not even be what you've approved, but maybe what you've received, because that's another way. If there's a lot of interest in a particular off-label use of a product, you'll see it through literature, you'll see it through grant requests, things like that.
And I had a couple things to add. One was if you have an internal advisory board, like of HCPs, that might be a resource you can use. If you don't have one and an acquisition comes up, that would be a reason you would adjust your ANA, as was mentioned earlier. The other thing I actually have seen is an allowance to actually talk to certain HCP customers, to go and interview customers so the acquirer is asking the company they're acquiring or want to acquire, and ask the customers to interview and get a good sampling of that to see what their utilization is.
That also is something that's typically done mostly on the commercial side, because they really want to know what the adoption is going to be in the marketplace. So they might already be doing that. So if you can sneak in a few compliance questions in there, it'd be really helpful.
Yeah, and a lot of times that's done by a third party. So investment bankers or somebody like that will do it, because you don't want the public to know who's looking at the company. So they'll just, say that they represent a client while they're doing that kind of diligence.
Great points. Okay, so this was the second part of that question. And again, Gordon, if you could lead us off. What can you do to curb off-label promotion of newly acquired products?
Yeah, so that's the real rub, because as you said, it's not illegal for the products to be used off-label. It's illegal for them to be promoted off-label. And I think where I'd start there is with the promotional literature, having that reviewed in detail by your regulatory department to make sure that the way that the product's being promoted does comply with its approved or cleared indication for use. And you'd also want to talk to the target company's sales force about how they're selling the product and how they're training their employees on how to sell the product. If there is extensive off-label use for the product, they should be training on how to respond to customer inquiries about off-label use or requests for training on off-label use, because they're certainly going to get it. And if they don't have training for the sales folks on how to respond to that, they're just going to get themselves in trouble. And then you'd also want to look at the training material to make sure that it's consistent with everything that the sales folks have been telling you.
I actually know of a circumstance where there was an off-label use of a product, about 66% of the products being sold. And the FDA specifically came to the facility and asked for 10 years of literature associated with that particular product, which was fascinating. It turned out just fine, I heard. So, but that's something that can happen.
The other, another situation that I saw quite a few years ago was a product that was approved for a surgical use, but was being used in an endo use. And, so internal versus cutting versus going in internal through the femoral. And in that circumstance, the company decided to go to the FDA and ask them, they were going to tell them, we've got this issue, we're going to do a clinical study, and here's what we're going to do. Help us plan the clinical study, here's our execution plan for it. And that was the way that the company dealt with it. But that was, I think, a pretty unusual circumstance, and something that was clearly missed in due diligence.
Interesting. This next question is kind of along the same vein, and we may have covered it already, but I'll ask the panel if they have anything to add. So a lot of times, companies are bought before their products are approved. And so there's maybe not even a sales force yet in place. How would you approach labeling review? So this would be assuming that the product has been approved, to make sure the indication for use aligns with the commercial objectives.
Yeah, I think that's largely an internal discussion that you'd want to talk to your marketing people to make sure you know exactly how they want to be able to market it. Again, what market need they're trying to fulfill with the product, and then make sure that they're talking with the regulatory folks so that there's that understanding between the two groups, so that marketing knows what regulatory can get and regulatory knows what marketing wants, and there's hopefully an overlap of that Venn diagram, and marketing understands what the costs might be to get more of what they want.
Sometimes you act as an intermediary in that discussion.
On your own side.
No, it's called breaking down silos.
Correct.
Like that. So I'm thinking of Amanda and Jesse and Nate, because a lot of these discussions, I mean, we're dealing with sort of the outcome, right? In this role of compliance, for example, or oversight as GC or whatever it may be. But these conversations really need to start very early on. Like we have this a product, device, drug, whatever it may be, and it works really great for X, or we think it's going to work really great for X. At that point, you should be thinking, right, Amanda, as this product, how is the FDA going to regulate it? Because I think someone mentioned earlier, I think maybe it was you, Gordon, that sometimes people will take this 510K path, for example, with a device, and it should really be a PMA. And so you're trying to market a device or a product for something that it's not approved for, which to Nate's point is, it's obviously very challenging. And I thought it was insightful where you talked about you've hired a bunch of salespeople to sell a product for an indication that they know how to sell it for, but it's ultimately not approved for that. So it's a very precarious situation to be in.
Well, it's an interesting thing because it's an economic choice associated with that, right? And so somebody made an economic choice, and yet they don't, like, to take, let's say, a 510K path, and yet they want to be able to make the PMA claims. Well, you made a choice, right? And so you have to live with that choice and convince them that you have to live with the choice.
Right. The other thing to remember is that people have short memories. So they might get caught up in deal momentum and be very excited about getting the product. And if it hasn't received clearance or approval yet, or even if there's some more development refining that needs to go on, there's some period of time that goes on between when you do the acquisition and when it starts to get commercialized. And during that period of time, frequently marketing people forget what the limitations that you talked about earlier, and they have focused the brass ring that they're trying to grab, and so you might want to remind them. You want to be able to remind them of the discussions that you had previously, and have some documentation of that. It's always helpful.
Great. Matt, I'll toss this next question to you. So what type of provisions can you include in your agreement, APA or SPA, to limit your exposure on not discovering a regulatory compliance or privacy diligence issue, or limiting liability on a known diligence issue?
Almost all of this has already been talked about, so I'm just going to regurgitate a number of things. It could be provisions that require pre-closing activities to close out particular issues. Your representations and warranties may be an area where you can include provisions that handle that issue. That may depend, again, on who you're acquiring from and whether there's an entity that exists afterwards, because there may be nowhere to go afterwards, right? And so you'll have to live with whatever the consequence. And then there might be escrow. One thing that was mentioned was escrow, which may be a generalized pool of escrow funds that could cover any number of issues, or a very specific set of escrow issues. A lot of times that happens in IP, where there's IP provision or provision in escrow for IP, very specific. And so you can include those. One thing I was thinking about too is milestones oftentimes come up relative to regulatory pathways. And that's always an interesting thing because it's tricky, because the acquiring company is the one responsible to then go get the milestones accomplished, right? And that may depend on how many people you acquire from the other company over, what sort of relationship they have with the prior company. There's a whole set of intricate kind of details you have to consider there. And my only caution there is be very specific about the language you choose in the milestones, and be very clear. Like, it's better to be clear on both sides, because the way where you're gonna end up if you're not hitting milestones is probably somewhere in the middle of whatever the milestone amount was. So,
Yeah, you should also specify the level of effort that you have to put into achieving a milestone. That's one. I mean, even if you get the specificity right on the milestone, um, the seller's going to think you should move heaven and earth in order to achieve the milestone, and the buyer's going to think you should do it if it's convenient. So you gotta bridge that gap, and the more specific you can be, the less opportunity there is for disputes afterwards about it.
And then there are circumstances where that's not going to work, right? If you buy a public company, there's no way that you're going to have a holdback or any kind of anything whatsoever. So in those circumstances, it really then becomes a negotiation up front, whether or not it's a big enough issue to reduce the purchase price. That's the only option you have with a public company. So it's really going to be dependent on the type of company you're buying and the type of issue, but those are all great options.
I almost feel like we could use an M&A attorney at this at this program as well, but because that's very insightful, Sandra. Oh, question? Yeah. Okay.
Is there ever a responsibility for a drug or device company to intervene in a situation where off-label use is being heavily promoted by a layperson, such as a celebrity, viral TikTok video, etc.? Could that situation result in lawsuits or claims, or is there enough protection just by saying, hey, that's not what it's for, according to us and FDA?
I think that's a complicated question depending on whether or not you have an association with that person. If you're paying them to be a spokesperson, then they belong to you, and whatever they do is your responsibility. If you're not paying them, then it's a little bit more complicated. But in my estimation on this, it all comes down to whether or not you really think there's a patient safety issue. And you probably, if there's a patient safety issue, you probably have to move a little bit more heaven and earth to try and address it. Whereas if it's just something that's somebody's like, yeah, I get less wrinkles because I use this cream or something, it's probably not something you need to do unless they're your spokesperson. But it's really going to depend all entirely on the facts and circumstances associated with the issue.
The one area I can see is social media posting, where you're actually the first affirmative post and it's a responsive post, then you may have a duty to do something to mitigate that issue.
Yeah, I was going to mention there was a warning letter in a case where someone liked a post that was off-label, for example. So, Gordon, I think you had a comment?
Yeah, no, I was just going to add, I think safety is the primary concern about whether you'd want to do something, and then just other general reputational risk. So it sounds like the question's kind of contemplating a crack job, that somebody's out there suggesting injecting, something to cure COVID or something crazy like that. You may want to disclaim that just to avoid reputational risk for the company.
Yeah, great feedback from the panel. One more question here. I know we're getting close to time, and Sandra, maybe I'll toss this one over to you to start with. Anything special to look for if a company operating under a CIA or that has completed a CIA?
Well, actually, I think it's, you never really want to be a company that's under a CIA. Let's put it that way. But if you have to be in that circumstances, it's actually very helpful because there is one external affirmation that you're actually doing things right. Because under a CIA, you have to put in an annual report to the OIG, Office of Inspector General, and then they will tell you whether or not they've accepted your report for the year or not. If they do that, then you can point to that and say, look at that, the OIG thought we were doing okay, all that. The other thing about CIAs is that everybody knows with the CIA that you have to do certain basic things. You have to have a hotline, you have to have a compliance officer, you have to have a compliance committee, you have to have written policies and procedures. So that checks a lot of the boxes that I talked about earlier, those kind of 8 areas that you'd want to look at anyway. So to a certain extent, although CIAs aren't great, they are actually very helpful if you're doing due diligence on a compliance program. Now, obviously, the risk of buying a company or being a company with the CIA is that if something goes wrong, even if it's not associated with the initial area that the CIA covered or what caused the CIA, then you're under a bigger scrutiny, under a bigger microscope. The government's going to come down harder on you if they see you as a recidivist. So that's the problem with buying a company that has a CIA in place or that's had one, and that if you have anything going forward, it's going to be count strike two. Somebody once said to me, having a CIA or finishing a CIA, you're really inviting the government into your house, and they're able to look at everything and not just the focus area of the CIA itself. So it cuts both ways. You're going to have a better compliance program generally if you have a CIA, but you're also going to be under a bigger microscope because you don't want to be a recidivist.
And I think there is some variability in CIAs. Some of them are, so you want to make sure you read and understand it very well. Some of them, you do kind of agree up front that practically if the government just makes an accusation, you'll accept it as, they don't have to prove, or they don't have to prove to the same standard that they otherwise would, that you've got a compliance problem. There may be automatic penalties that are imposed, and then the government loves to find an opportunity most CIAs are for 5 years. They love to find something wrong during that 5-year period and then tack on additional time when they said that the non-compliance was occurring. So they can be helpful. Like Sandra said, they cut both ways. They can be helpful in that you're going to have a better base compliance program, but it's also could be easier for the government to take additional action against you in the future.
All right, well, that concludes our program. I wanted to thank our panelists again and thank everyone for attending today. So we'll start our reception now. Thank you.